Hello, National Book Festival fairgoers. My name is John St. Amour, and I am the Assistant Section Head in the Public Information Office, and it is my delight to represent the U.S. Copyright Office today to lead a discussion on copyright. I have a lot to discuss, and there is a quiz at the end, so pay attention. Today, we're discussing copyright, the engine of free expression, a phrase coined by the Supreme Court in their 1985 Harper and Row versus Nation Enterprises decision. And every one of you is a part of this engine of free expression. You'll see why you're a part of copyright very soon. The mission of the Copyright Office is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial, expert advice on copyright law and policy for the benefit of all, thus enriching the nation's culture by empowering and connecting all of us who make up the copyright community. Who is all? All is, of course, the creators of original works, but it's also the people who get to read, view, watch, listen, or even step into the work. And then all of the people who are part of the industries in between the creator and the user of the work, like the book publisher, or the art dealer, the music licensing company, the movie distributors, the customer service and register employees at the bookstore, even the stock person at the toy store. But wait, I'm getting ahead of myself. The first question is, what is copyright? Copyright is a type of intellectual property that protects original works of authorship as soon as an author fixes the work in a tangible form of expression. Now, works are original when they are independently created by a human author and have a minimal degree of creativity. Independent creation simply means that you create it yourself without copying. The Supreme Court has said that to be creative, a work must have a spark and modicum of creativity. Now, a work is fixed when it is captured, either by or under the authority of an author, in a sufficiently permanent medium, such that the work can be perceived, reproduced, or communicated for more than a short time. For example, a work is fixed when you write it down or record it. Now, in copyright law, there are a lot of different types of works, including paintings and photographs, illustrations, musical compositions, sound recordings, computer programs, books, poems, blog posts, movies, architectural works, plays, and so much more. And everyone who creates one of these works is a copyright owner, no matter how young or how old the person is. Kids in school making art, writing stories, writing music, the grandmother who writes poetry, a retiree who takes up painting, a survivor who writes her memoir, a comedian who writes his own jokes, a gamer who decides to write his own computer program. Anyone, any of you who creates any one of these works, you are a copyright owner. There are some things, however, that are not creative, like titles, names, short phrases, and slogans. Familiar symbols or designs like hearts and clovers, right? Mere variations of typographic ornamentation, lettering or coloring, fonts, for example, and the mere listing of ingredients or contents. And always keep in mind that copyright protects expression and never ideas, procedures, methods, system, processes, concepts, principles, or discoveries. I have some examples of works here on my table, which have been registered with the Copyright Office. This book here is a cookbook. And while I just stated that mere listings of ingredients is not protected by copyright, a cookbook is so much more. There are lots and lots of instructional text, and the best part of a cookbook, the photographs. Or if you're like me, maybe the worst part, my dishes never look this good. And while we think of sculptural works as things like bronze statues or plaster busts or even something large like the Statue of Liberty, which I think is the largest thing we've ever registered, sculptural works can include your favorite stuffed animal, like your teddy bear or maybe one of these guys. A sculpture work could be very small, like this here, a goose, who inside lays the golden egg. And what's inside the golden egg, I wonder? A little bit of perfume. Other things might include paint by numbers, like this here, Wizard of Oz, paint by numbers. Or, I think my son's favorites, masks from Star Wars. Oh, and of course, musical works. What's neat about a CD, and yes, some places in the world, people still buy LPs and CDs, as not only do we have the musical works and the sound recording inside, there's also wonderful cover art and photographs that are also protected by copyright. In the literal sense, copyright means the right to copy. But it's more than just that. It's a bundle of exclusive rights given to the creator of a protected work. These rights together are an incentive for you to feel comfortable putting your work out there with the potential to reap the financial benefits of your creation and protecting you in case someone else infringes your rights, accidentally or purposefully. And these rights are yours, whether you publish the work or not. It's the copyright owner's exclusive right to determine how and when you'll put your work out there to the world. And your rights, they last a pretty long time. The length of copyright protection depends on when a work was created. But under the current law, works created on or after January 1st, 1978 have a copyright term of life of the author plus 70 years after the author's death. But Johnny, you say, what about the users? What are their rights? Well, I'm glad you asked. It is important to know that we are all also copyright users. When we read books, watch movies, listen to music, or use video games or software, we are using copyright protected works. So even if you're not the owner of a work, you still may be able to use it. In addition to buying or licensing work, the Copyright Act includes exceptions and limitations to the author's exclusive rights. They're not completely unlimited. The Copyright Act's exceptions and limitations are found in sections 107 through 122, and they include fair use for purposes such as research, teaching, and reporting, to name a few. The first sale doctrine, which allows you to borrow material from libraries and rent videos at those red vending machines. Some reproductions or copies made by libraries and archives is allowable. Even certain performances and displays of works, to name a few, are allowable by users under the Copyright Act. Of course, you can also freely use works that are in the public domain. Now, works in the public domain are essentially works whose term of protection has ended. Now, currently, all works published 1925 and earlier are in the public domain in the United States. And while registering your work with the Copyright Office is not mandatory, there are some pretty important benefits to filing a registration. In addition to making a public record of the ownership of your work, the first step in creating a chain of title for your work, a registration is required to use the courts to enforce copyrights through litigation. Since 1870, the Copyright Office maintains public records of registrations. But we're not stuck in old-fashioned ways. Our registration system is fully electronic, and the law changes over time as well. This December, for example, the Copyright Claims Board will begin, aimed to help smaller cases of infringement out there, where going to federal court would be much too costly. This tribunal will really help individual artists who are just trying to protect their modest work. And there's so much more we do as an office to educate the public on all things copyright. The best resource for copyright is our website, www.copyright.gov. Not only do we have all sorts of circulars, publications, and pages of information, we also have a host of videos on copyright topics, from basics to more complex issues like fair use and the Music Modernization Act. And we're making more. So please visit us on our website, www.copyright.gov. Oh, I bet you forgot. There is a quiz at the end to test what we've learned today. Or you can call it trivia. So let's play. For a work to be protected under copyright, what did I say? It must A, be original, B, include a copyright notice, C, be of professional quality, or D, have a value of $35. Well, it of course doesn't have to have any specific value, but it does have to be, the answer, A, it needs to be original and fixed in some sort of tangible medium. All right, let's see if you remember the answer to this next question. A work is protected under copyright when what happens? A, the author mails a copy of the work to herself. B, as soon as the work is created and fixed in any format, as soon as the work is submitted to the Copyright Office. Or D, once the work is published or displayed publicly. Well, I can certainly tell you it's not A. We hear this a lot at the Copyright Office. What if I just mail a copy of the work to myself? That's called a poor man's copyright, and it is indeed poor. It offers you no protection. The answer here, of course, is B. As soon as a work is created and fixed in any format, the work is protected by copyright. All right, let's see what we have for our next question here. What year did I say the copyright was established in? Was it 1790, 1870, 1897, or 1909? Well, actually, this is kind of a trick question. It's a 50-50 chance here. It's B or C. I did mention in 1870. That is when copyright was centralized here at the Library of Congress. But the Copyright Office actually didn't become a separate department until 1897. So if you said either B or C, you're actually right on both accounts. All right, what do we have next here? If a work is in the public domain, what does that mean? Does it mean A, it exists on the internet? B, access to the work is free of cost? C, it is available at a public library? Or D, the work can be freely copied and used? Well, I'm going to take one off of the chart for you. It's certainly not A. You have to know that just because something is on the internet, while it may be in the domain of the public, it's not actually public domain material that can be freely used. Rather, the answer in this case, of course, is D, the work can be freely copied and used. The Copyright Office strategic plan references the engine of free expression. Now, I said that really early in my presentation today. Now, where did that phrase come from? Did it come from the U.S. Constitution? Harper and Row Publishers, Inc., First Nation Enterprises? Did President Grant say it? Or did it come from the House report on the 1976 Copyright Act? Actually, the answer here was, of course, it came from the Supreme Court in their decision in the Harper and Row Publishers versus Nation Enterprises. Well, I hope you got all the answers. Oh, I'm sorry, I forgot one more, of course. What is the largest thing the Copyright Office has registered? Was it the Brooklyn Bridge, the St. Louis Arch, the Statue of Liberty, or the Disney Castle? Well, I've walked over the Brooklyn Bridge, and it's not the Brooklyn Bridge. But in this case, of course, I mentioned the Statue of Liberty. Yes, we believe it is the largest thing the Copyright Office has ever registered. And you can go to our website, www.copyright.gov, and learn all about the Statue of Liberty, as well as information about our on-site exhibits. So I would like to thank you for coming to the Copyright Office's presentation on copyright. Again, I'm John Sainamore, and it has been so much fun to spend this time with you. Thank you, and we're now open for questions.
So the first question is, if I copyright a short story as an unpublished work, how does the protection rights change, if at all, if the story eventually is published?
Oh, excellent question. The rights don't change at all if the work is published. It's, of course, you have benefits if you file a registration that you're afforded, extra benefits in the law for registration for an unpublished work. You're not obligated to file another registration should the work later be published, although you may if you want to show a change of that status in the public record. But in terms of your copyright ownership and the term of copyright lasting for your life plus 70 years, none of that changes.
Okay, thank you, John. Our next question. Can feature articles be protected by copyright before their submission to a publisher, such as a magazine?
Absolutely. You certainly can file articles that are not yet published with the Copyright Office, we get a lot of unpublished content from things that may be published or may not be published. Sometimes you turn things into publishers and they may decide to wait to publish for a long time. And so understandably, you want to make sure that you're protected for your work if you're going to be putting it out there. So absolutely, we accept registrations at any time during the life of the copyright.
Okay, thank you. Our next question, government publications in the public domain. For example, could someone freely use a government publication in a work of fiction as part of their story?
As long as yes, and I didn't mention that, works that are created by the federal government are in fact in the public domain. That's a section of the law as well. And so those things, like the law itself, for example, is not something that can be protected, or the House report on the Copyright Act. Those kinds of government publications, our own circulars here at the Copyright Office, those things are not protected by copyright and can be used in any material.
Thank you. Next question. Why did the Statue of Liberty need to be copywritten?
Well, if you think of the time, first of all, many things were happening. Of course, Bertoldi, who is the person who created that, they needed to raise funds. There were lots of different ways in which funds were going to be raised for Statue of Liberty. One way was to try to sell smaller versions of it. And so there was going to be reproductions that were going to be made of the Statue of Liberty in the United States. That was one of the ways that they were going to raise money, in addition to the crowdsourcing they did, kind of the first example of crowdsourcing they did in the newspapers. But also there was, photography was still relatively new, and so there were questions about taking the photograph of the work, particularly prior to it being installed, and selling and distributing those copies. So there were questions about Copyright Act, but primarily it had to do with the need to make reproductions of the work. And that was a way for Americans to get excited about this gift from the French.
Who owns the copyright to the Statue of Liberty?
Well, nobody now. The copyright has long since expired, but it's my understanding that Frederick Bertoldi, who created the statue, is the person who filed the registration.
Thank you. Next question. What are the implications of requiring that a work be fixed on cultures with primarily oral traditions?
Well, there are many ways. It's one of the requirements. Fixation is a requirement. Of course, there are many ways to fix works, even text. Text does not have to necessarily be written down. Text can be recorded as well. But fixation is a requirement under U.S. law to be protected in the United States. Passing a story from friend to friend, friend to friend, friend to friend, if it's never written down, does not enjoy protection until that point. But it can also be fixed in a sound recording format, in which case that text has been captured and is in a reproducible format that can be reused, and that would be protected by copyright.
Thank you, John. Our next question. If a professional artist just puts the C in a circle at the base of each work of art, is further registration necessary?
I didn't mention copyright notice earlier. So a copyright notice generally is the copyright symbol, which is the C in the circle, or the word copyright, or its abbreviation, COPR, oftentimes followed by the year of publication if it's a published work, followed by the name of the copyright owner. Now, none of those aspects are required to hold copyright. It used to be in the past, but when the United States joined the Berne Convention in 1989, that requirement was dropped. The copyright notice on a work is to let the reader know, or the person viewing the work know, that the work is being claimed as copyright protected. So it's a notice. It's a notice to the viewer, to the reader. It's not a replacement for registration. So a notice alone is not going to be sufficient if someone were to infringe the work and you needed to litigate in court. You would still need to file a copyright registration for that purpose. And actually, the two things work together so that a person couldn't argue, that it was an accidental, they didn't know. Well, there was a notice on the work and the person filed the registration. And so, anyone who has any ability to do just minimal due diligence would know that that work was protected by copyright. So the two pieces work in tandem. It's not a requirement, but of course, the law provides benefits for doing both.
Thank you. Can I paint images from medieval manuscripts and use them in my book?
I'm assuming these medieval manuscripts, you're talking about painting things that are old and that are in the public domain. Certainly, you can create your own version of those works and potentially could register those. There needs to be a certain difference between the original and your version. If it's an exact copy of something that's already protected that's no longer protected by copyright, then that won't work. But if you're creating your own version of a work, a sketch of something that is public domain, yes, that's a derivative work. And since it's public domain work, you have a right to make the derivative work without getting permission and then being able to utilize that in any way that you choose.
Does a work have to be copyrighted in order to be included in the library's records, Library of Congress records?
Well, the Library of Congress collects material in many different ways. There is a significant amount of material that comes through copyright registration, published material that gets handed over to the library. And the library has selection officers who determine whether or not the work would be included in the Library of Congress's collections. There's also many other works that come to the Copyright Office through philanthropy and other donations and things. So the library has different avenues to acquire over the years that have acquired their collections. Again, the copyright notice itself is not a requirement, but often published material has copyright notices. But again, a notice is not a requirement. And I'm not sure about other material that the Copyright Office receives through other means. Because the Copyright Office, the Library of Congress, even through philanthropic donations, some of that material isn't even published, and yet that becomes part of their collections. It's kind of housed separately and treated differently than published content. And whether there's copyright notices on that material or not, I'm really not sure.
If works not registered with U.S. copyright can't have litigation, then how can they be protected?
Well, litigation isn't the only thing a person can do. There are other measures a person can take. For example, if you find your work on another website, you can do what's called the DMCA takedown. A registration is not a requirement to enforce your rights through the internet in that way. There's also going to be coming for small claims court. As I said earlier, the Copyright Claims Board will be handling some smaller cases, and registration may not be required in those cases. But there are other legal measures. You'd have to talk to an attorney if you've been infringed against and you're wondering what some of your legal options are. You may want to talk to an attorney who's knowledgeable in the area of copyright law and can provide you with copyright advice. And if you're not sure, contact your local bar association and they can point you in the right direction.
If you don't register copyright, is your work still protected?
Yes, under the law, you have to have those two pieces, right? The creative spark, some sort of creative work, a modicum of amount of creative work, and then you have to have it fixed. And as long as you have those two things, the copyright, as a law, protects the work.
Is it okay to use the first 30 seconds of a song if you are not profiting from the use of the song?
Well, I can't answer that straight up, to be honest with you. But because, as I said earlier, there are circumstances within the law where it may be okay to use a portion of a work under certain circumstances. Fair use comes to mind. Whether or not your particular use of 30 seconds of a song would be considered fair or not is something that you would have to investigate. You can go to our website, copyright.gov. We have a fair use index with court cases that can help steer you in the right direction. I wouldn't necessarily categorize the use of 30 seconds of a song to be automatically okay. On the other hand, I can't be here today and say that you can't. It's going to depend on your use, the particular use, the way in which you're using it, and how that falls within your user rights. Of course, getting permission from the copyright owner is always a great step. Sometimes you can get permission without the need for a license. So that's something that you would have to either contact the copyright owner or review the provisions of fair use.
Okay, are works of antiquity in the public domain by default, say Da Vinci Codex or Michelangelo sculpture?
Yes, they would be they would be works of antiquity would be in the public domain. All right. Well, that's the end of our questions. And I want to, again, thank you all for participating in the National Book Festival, for coming to this presentation for the Copyright Office. Again, my name is John St. Amour. If you have any questions, hit our Contact Us link at our website, copyright.gov. And I hope to see you again sometime. Thank you so much.